Hi everyone, my name is Maddie Brumley. In this presentation, I'm exploring an important ethical and legal challenge in family counseling. What happens when a counselor meets privately with one family member without others present? This issue might sound simple on the surface, just one private conversation, but as family therapists, we know that even a single confidential meeting can shift the balance of the entire system. This is actually one of the most concerning and ethical legal dilemmas in family therapy. Today, I'll discuss why this issue matters, what the ACA, MBCC, and Colorado state law says about it, and how we can navigate it ethically when it happens in practice. I'll also walk through a scenario or two when possible of different ethical solutions. Okay. So I want to start with the problem itself. In family counseling, clients often ask for private time. A teenager might say something like, "Hey, can I talk to you about something privately? Please don't tell them." That's going to be an incredibly common request, and it puts the counselor in an ethical tightrope situation between parents, caregivers, between the intended group that you're therapizing. If we agree to meet with them privately, we can risk breaking trust with the rest of the family. If we refuse, we can risk losing trust of that participant and that client within the family, and that can break family ties down. And that individual probably just needs a safe space to talk, and that creates an unsafe space in the therapy room. The harm potential can be huge resulting from this. It can rupture trust between family members or between the family and the counselor. It can create a hidden alliance, what systematic therapists call triangulation, where one person pulls the counselor into a secret coalition. Third, legal and ethical boundaries can blur fast. We may hear about abuse, self-harm, or other mandated reporting situations, such as criminal behavior, and be forced to break confidentiality, which can seem as if that was our intention the entire time when it really wasn't. We want to provide confidentiality when able to. Finally, it can derail treatment progress. When clients feel secrets are being kept, family cohesion can start to deteriorate. And this is why Green and Hansen, as cited in Gladding, emphasize that meeting one family member privately without clear boundaries set and placed and given to the other family members can be one of the most dangerous things for family counselors, and it is why we have to tread carefully around this situation and this subject. In our professional code, the ACA states in section B1 that counselors must protect confidentiality and privacy, clearly explaining the limits of confidentiality before treatment is even started. Section A2 requires informed consent before counseling begins, including explaining how confidentiality will function when multiple clients are involved. Section B4 reminds us to respect individual rights to privacy and avoid actions that can harm our clients. And Section I1 tells us to use sound ethical decision-making and consult others when dilemmas arise. So, under ACA, private meetings aren't automatically unethical, but if they aren't lightly or heavily discussed beforehand, there's informed consent involved amongst all family members and clients that you're working with at the same time, so they understand clearly the boundaries that are set before they step into a family session. If you are going to include providing separate sessions for individuals within the family. Families might demand transparency. All they're looking for is clear agreements and careful documentation, and that's really what everybody wants. You're going to want to make sure you document everything carefully, especially if it comes to mandated reporting situations. Now, turning to the MBCC's Code of Ethics, the stresses the MBCC focuses on are of the same core values: informed consent, clear explanation of confidentiality, and minimizing harm. It states that counselors must operate within legal parameters and disclose the limits of confidentiality, especially when working with families or minors. And it emphasizes avoiding conflicts of interest, which is exactly what secret meetings can create. A lot of the time you're going to be working with families and families that have minors involved within the therapy, and that can create different barriers. You're not always going to be working with just two people in a couple and their relationships, or a newborn and their family. Sometimes it'll be entire families coming and engaging in the therapy sessions. In Colorado, there are specific state laws that we have to abide by, and since I will be getting my license in Colorado, I looked into the state-specific laws here. Under the Colorado Revised Statutes, Title 12, Article 43, Section 214, to be exact, information disclosed in therapy is legally confidential. Counselors can only release it under certain and specific exceptions like court orders, client consent, or mandated reporting situations such as child abuse or threats of serious harm. There's another key clause: if client is a child whose parent or guardian consented to the counseling, disclosure must generally be made to the parent or guardian unless a legal exception applies. So, that means if a child is having an issue and the client it's a situation that needs to be mandated reported, they're reporting abuse, they're reporting anything that needs to be sent to CPS or any child welfare service, that disclosure is going to be made to the parent or guardian unless there is a legal exception. And the Colorado rules for licensed professional counselors require us to maintain competence in legal and ethical standards and avoid harming clients or misusing confidentiality. So, in short, Colorado law recognizes confidentiality as a legal right, but clearly defines its limits, and those limits sometimes override what clients want to keep private and what parents want access to. A lot of the time back home in Pennsylvania, the state law allows parents who have signed minors up for therapy to go over therapy notes and things that they specifically want shared if it's signed beforehand. It's very interesting. My cousins went through it. So the tension you can face with that, ethical codes very much encourage us to practice client privacy and promote trust. A lot of legal statutes can require disclosure in certain situations, even if we wouldn't want to disclose those situations or those things shared with us in therapy sessions. Normally, the state law might require us to. It's also something that we need to make sure to maintain balancing confidentiality and the duty to protect our clients, which is something that everybody strives for, and also through systemic transparency, client autonomy, and legal obligations that we hold. It's important to make sure that we are up to date on ethical laws, legal laws, what could if anything could put us in an ethical dilemma. Let me illustrate with a scenario. So imagine a family with a 16-year-old client. There's a mom, a dad, their daughter, who is 16, is named Mia. They've been in family therapy for a long time. They've done it for a while. After a session one day, Mia comes to you, asks to meet privately. She's scared to talk in front of her parents about some things, and she really wants to tell you a secret. During the private meeting, she tells you how she's super worried about her dad's drinking. It's becoming a lot lately. He's coming home late at night. He's slamming doors, and he's yelling a lot at mom, and she can hear it. She insists that he's never physically hit anybody, but she feels unsafe sometimes. She doesn't want to bring it up around her parents. She doesn't want to bring it up to her mom. She doesn't want to bring it up to her dad. She's 16 years old. She's a sophomore in high school. She begs you not to tell her parents because she's afraid it's going to make things worse. Okay, so you now have several competing responsibilities. You have to protect Mia's confidentiality, avoid undermining family trust, stay within Colorado state reporting laws, and maintain systemic neutrality as a family counselor. One possible approach is option A, transparent, pre-negotiated private sessions. In this approach, you could meet privately with Mia, but you would have clear established boundaries with her family and parents beforehand, and it would serve as a separate session that was only you and Mia's session. It wouldn't be a part of the family therapy. The informed consent would already be withheld. It would be given before this started. The parents would understand it as well, being that she's a minor. Anything shared could potentially be disclosed to the rest of the family, but it would be a private session, and you would be under the concern of Mia and you would be focused on her. This will honor transparency. It can maintain trust between client and therapist and family, vice versa, the triangular theory. Balances confidentiality with systemic integrity. And some of the cons could just be that she might hold back a little bit, or the parents might still feel a little bit uneasy about the private sessions. Another approach is option B, is to decline private sessions entirely. You could tell Mia that your family counseling policy doesn't include individual sessions except in cases of risk or crisis. You could very much encourage her to bring this up to her parents, that she's interested in seeking private therapy sessions. I wouldn't encourage a minor to, and this is just my personal opinion, I wouldn't encourage a minor to bring up her personal concerns about her father's drinking when she's the only child in the home. I think you can bring that to the attention of her parents, that she wants to see a therapist and just talk about some things privately. And I think try to respect her autonomy and confidentiality as much as you can. This can prevent hidden alliances, and I mean, at first it might make you feel like you're losing a little bit of rapport with her, denying, but it's just going to make it better in the end, you not dipping your toes in between individual and family. Personally, I would choose option A. I would approach it ethically. I would review the informed consent. I would clarify confidentiality limits before meeting. I would assess for risk. I would consult with my supervisor, discuss themes, document everything, and revisit boundaries in sessions that come after. To prevent harm, I want to discuss confidentiality before therapy begins, clarify that anything shared might become relevant to family therapy, avoid long-term individual sessions unless justified, and keep detailed objective notes. So, to summarize, meeting privately with one family member may seem helpful, but it's one of the most ethically and legally risky actions a family counselor can take. Gladding reminds us that counselors must remain neutral facilitators, not secret keepers. The ACA and MBCC codes require informed consent, confidentiality boundaries, and minimizing harm. And in Colorado, the law grants confidentiality but clearly outlines expectations, particularly for minors, and mandated reporting. The key is not to avoid difficult conversations, it's to approach them with transparency, consultation, and compassion. Family therapy works best when everyone in the room knows ground rules and trusts that the counselor's allegiance is to the process, not to any one person. Thank you all so much for listening. I'm really looking forward to hearing how you might have some different opinions or handled the situation differently, and I'm really excited to see all the different ethical approaches that I've taken. My references for this presentation are Gladding 2018, the ACA Code of Ethics 2014, and the MBCC Code of Ethics.